Now that we have understanding of these three terms, what rights are, what property is, and what we mean by the term intellectual, we should be in a position to move forward and give a definition for intellectual property rights. Intellectual property rights generally protects applications of idea and information that are of commercial value. Now, this branch, intellectual property rights, generally protects applications of ideas. They don't protect ideas per se. This is something which we need to understand. Ideas in themselves, by themselves, cannot be protected. But applications and expressions of ideas can be protected. Now, the best instance would be, or one illustration would be, the genre in literary works, crime fiction. You would have seen that almost every novel in crime could either be a whodunit or how somebody did something. So this is the genre. There is a plot, there is an event that happens, and there are a set of characters all looking suspicious, and there is a person who would come to solve that thing, and eventually there could be some twist in the tale. Eventually the crime is solved, or at least the person who reads the novel is given an impression that he was a part of a process of solving something. Now, this genre has been in existence for a long time. People of different calibers have written crime novels, and they all follow the same plot. There is an event which has to be solved, and somebody solves it. There is a suspicion on the most possible characters, and somebody else turns out to be the person who actually did the crime. So that's the whodunit part. The how he did it part is the crime is there, and then somebody explains or tells the readers how this crime was done. So these are the, there could be other ways of this, but it's this genre, this group of fiction is predictable by its nature, because the setting is always a crime, and there is an explanation of why the crime happened or how the crime happened or who did the crime. But look at the number of books that have come out of this genre, and look at the number of authors. Some authors like Agatha Christie, she has written most of her books on this genre, and still each book is different. It could be the same idea, it could be the same main character who solves these plots. Nevertheless, each idea is expressed in a different form. And because it is expressed in a different form, each idea, as it is expressed in a different form, can have a separate right. So, copyright subsists in all the books of Agatha Christie, and there cannot be an objection that they are all crime novels or they are all works of fiction. So they are all the whodunit model. In some cases, it's the same protagonist who solves these problems. So that cannot be a reason to say that the idea is the same. As long as the expression is different, you can have different rights subsisting in those ideas. Now having said that, now we can venture to look at the nature of intellectual property right. Now, we have analyzed these terms, and these terms have actually thrown up certain traits which we can identify as traits that are common for intellectual property rights. If not common, traits which actually characterize this group of rights. The first thing is that they are protectable by law. That's the first thing, because there could be very valuable information and idea which the law does not protect. But when we talk about intellectual property rights, we are talking about a specific right, be it a patent, be it copyright, trademark, design. There are a list of rights which are granted protection. So the first thing is that these are enforceable. So when we say right, we mean enforceable. So that's the first thing. For something to qualify as an intellectual property right, it should be enforceable. It should be in the nature of a right. There should be an entitlement. Somebody can claim something used on it. And if there is a violation of that right, there should be a remedy. So patents offer protection. If there is infringement or violation of a patent, there is a remedy. You can stop the person from asking him not to do that thing, or you can claim what we call monetary compensation or damages. So the first thing is they are enforceable. The second trait is that they are different from normal property. We can use the word intangible. These rights are intangible. You can't touch and feel them, but they manifest in the end product in some way. And because they are intangible, they need to be described by some means. So the description part has led to various forms of recognizing the descriptive part. In a patent, it is described in writing by something called a patent specification, and this patent specification undergoes a process, what we call patent prosecution, within the patent office, and it emanates as a patent right. This entire process, in a very simple language, we can call it registration. So rights, they are enforceable and they are capable of being registered. The same is for design. Designs can be described and they can be registered. Trademarks. Trademarks can be described and they can be registered. Copyrights. Copyrights can be described and they can be registered. But because of an international arrangement called the Berne Convention, it is not necessary to get a registration of a copyright to enforce it. Mere publication, you would have seen in many books, there is a copyright notice in the initial pages where the copyright is held by the author or by the publisher. You might find in various websites in the footer, there is a copyright notice. The fact that you have put a copyright notice and most likely with an entity's name and the year in which it was published, and the fact that you are published is good enough for you to say that you are the owner of the right. So copyright is an exception where you do not need to register it for enforcing it, but registration is, there is a possibility, there is a way in which you can register it. So that's the second part. The first thing about intellectual property rights is that they are enforceable. The second thing, they are capable of being described and concomitantly being registered. So that's the second part. They can be registered, which brings in a whole lot of things. There is an office, there is an authority which analyzes the right and gives and scrutinizes it and then verifies it with other things and then grants you a title. So the process of registration in patent law is called patent prosecution. It happens at the patent office. Only when the written part, that is the patent specification, go through the process of prosecution does a person get a grant. When we mean by a grant, we mean a title of patent. So enforcement, registration. The third thing about an intellectual property right is the fact that you can easily replicate it. Now I ask this question, how much does it cost Microsoft to come up with the first copy of Windows? Say Windows 7. It'll be a few $1 million because you look at their R&D, their investment, their staff salaries, a whole lot of things would have gone into creating the first copy of Windows 7. How much does it cost anyone to make another copy of Windows 7? Next to nothing. You can just copy it, whatever is there in a CD, onto a hard drive or to a pen drive if it has the capacity to do it. So the cost of making the second copy is next to nothing. So this defines yet another trait of intellectual property right. It is difficult to get the first copy out, but once the first copy is out, it is easily replicable. Now, this is also true for books. Books an author may take years to write the book. It does not take much to scan the book and put the copy of the entire pirated book somewhere in the cloud. Similarly, a movie may take months or years of effort to complete, but we hear constantly about pirated versions coming out within just few days of screening of the movie in the theaters. All these things tell us that though it is hard to create an intellectual property, it is easy to replicate. Now, this is another trait, that it can be reproduced easily. Yet another trait, which is not common, but nevertheless it's a trait, is the fact that it requires effort to create intellectual property. As we said, there is intellectual effort involved in it, but in today's world, in a modern world, sometimes this effort comes from research and development sometimes. And sometimes it requires many people coming together to create intellectual property right, especially when we are talking about inventions. And today, gone are the days where an inventor could be in his garage and come up with something new. Today, the sciences and technology has progressed to such a level that most of the inventions, and this is also true about academic writing in the scientific, in science and technology, most of the time they are co-authored. We would very rarely find papers written by a single person. So this is true for patenting too. Many of the patents are group efforts done sometimes by teams that are spread across in different countries. They put their efforts together and they come up with an invention. So they are group efforts. So the fourth point is the fact that it requires an intellectual effort to create these rights. So they are creations of the mind, but it requires an effort to create these rights. Another trait or something inherent in the nature of intellectual property right is that these rights, once they are created, they are valuable. There is commercial value, or the fact that these rights can be used in trade and in business makes them valuable. So they are capable of being enforced, they can be registered, they can be duplicated, reproduced in many numbers. It involves effort to create them, a creative effort, sometimes by many people put together, and it has commercial value. Now, these are 5 points which we have tried to cull out, which define the nature of the intellectual property. Economists have also used 2 more terms to understand intellectual property. They say intellectual property by its nature is non-rivalrous and it's non-excludable. Non-rivalrous means the use of intellectual property by one person does not cause rivalry or does not take away the enjoyment of the same intellectual property by another person. Now, to understand non-rivalrous nature of intellectual property, let us imagine empty room, an empty room which is in the size of a normal classroom. You just imagine an empty room and imagine that you own this empty room. You have complete power over this empty room. Now, if there is an entrepreneurial spirit in you and you want to make some money with this room, there are multiple ways in which you can use this room to make money. You could rent this room out for a couple of people to sleep. You can have some bunker beds and you can make some money out of it. Now, if you want to stretch it a bit more further, you can convert the room into a classroom by which you can make more people sit than sleep, and you can make some more money, or you can change your enterprise into a different one. Now, if you get more enterprising and if you want to get in more people into it, you can remove all furniture and make it into a place where people come and generally socialize with each other for whatever reason. They could eat, they could talk to each other, and if you really want to stretch this forward, you could have some kind of a party where people don't mind being at close proximity with each other. Now, these are things which you could do to use or maximize the use of your real property, which is your room. Now, at best, and depending on the tolerance level of people, you could cramp in close to 100 people into that room. Yes, it gets tough, the air gets hot, ventilation becomes a problem, but still, if people's tolerance limit is high, you may be able to push in 100 people into a room of average size. Now, if you try to put 500 people into that room, there could be police at your doorsteps, because that's simply not possible. So that tells us real property has its limits on enjoyment. These limits are not there when it comes to intellectual property right. Imagine a best-selling book. How many people can read that book at one time? Yes, the person who's reading it. another person who's sitting next to the person who is also reading it. Yes, there could be a group of people around that person. Say it's a new book which has been released for the first time. Somebody stood in the queue for 12 hours and got the book. Assume it's a very, very popular book. You could have a group of friends who don't mind being pushed around, looking into the page and reading it. If you're more creative, you could scan the page and put it on a computer screen or project it on a computer screen, and a whole lot of people can read. If you even stretch it further, you could scan the page, put it on cloud, and anybody who has access to that document could see it. And that could run into millions or as many devices you have, you could see that. So this is a trait of intellectual property which distinguishes it from real property. Real property has limits in enjoyment. There are no limits in enjoying an intellectual property right. This is what we mean by non-rivalrous. Use by one does not take away the enjoyment by another. So all the people who crowded around a person who bought a copy of a best-selling book equally enjoy the intellectual property right. They were able to use it without affecting the right or without affecting the enjoyment quotient of the other person to use it at the same time, which would have been different if people were crammed into a room. There are limits to which people can use a room, whereas there are no limits to how an intellectual property can be used. So this is what is referred as the non-rivalrous nature of intellectual property. Intellectual property also becomes non-excludable. This is another trait which they say it's non-excludable. The fact that intellectual property can be used by some, you cannot stop others from using it. For instance, somebody scans a book and chooses to put it on a live telecast on YouTube. So what he is doing is he's just holding a page and giving sufficient time for people to read the page. Then he's moving to the next page and he's just holding it in front of a camera. And he is live streaming this on YouTube. So the book is available for live viewing for any number of people. Now, the fact that he has already put it on YouTube, there is no way you can exclude a person who has got access to YouTube from enjoying it. So there is, once it is put in a way in which others can see it, there is no way you can stop others from or exclude others. So this is again a trait which intellectual property enjoys. Once a medicine, or say it's a life-saving medicine, is out in the market, it is possible for the competitors of the manufacturer who have manufactured this medicine to take the medicine, analyze it, and even without going back to the manufacturer, to create a copy of it. So once it is out, there is no way you can exclude people from taking effect of it or in understanding how that particular thing was done. These two traits, non-rivalrous and non-excludable nature, is something that is shared by what economists call public goods. Public goods, by definition, are non-excludable and non-rivalrous. For instance, national security. You cannot exclude people from national security. Everybody gets it, and you cannot specifically say that national security is only for few people, because if a country's boundaries are bordered, everybody inside gets the benefit of it. Now, definition of intellectual property right. There is no agreed definition of intellectual property right. We don't have an agreed definition. In fact, as I mentioned, if you look at a dictionary meaning, intellectual property rights can be defined as rights that protect applications of ideas and information that are of commercial value. It's one definition. The rights that protect the products of creative labor, it's another definition. You will find multiple definitions around this, and some definitions would actually give you a list of things. It's more like a grocery list, a list of things, and say that these are all intellectual property rights. For instance, the WIPO, which stands for World Intellectual Property Organization, which is an international organization under the United Nations which deals with intellectual property rights. The WIPO has a definition it's an expansive definition which is more like a grocery list. It includes many things under the ambit of intellectual property rights. It talks about the things on which the rights are manifested, and it also talks about the actual rights. Now, you will find in the WIPO's definition that they talk about patents, they talk about copyrights, they talk about trademarks, designs, and similar rights. The problem with the WIPO's definition is the WIPO's definition does not take care of the new and emerging intellectual property rights. There are some intellectual property rights that are emerging as we speak. It does not take that into factor. Secondly, there is no yardstick by which you can understand intellectual property rights. It's simply not there. So we could come up with a definition of intellectual property right either as rights which belong to a particular nature, which protects creative and intellectual products that come out of human labor, or you could have a list of things on which an intellectual property right may manifest. So the WIPO's definition is a definition which is an inclusive list, and there could be new things that come into the list, but the WIPO's definition does not offer, apart from referring to it as products of creative labor, it does not give us anything more for us to have a uniform definition for defining intellectual property rights. Types of intellectual property rights. Intellectual property rights, there are many different varieties of intellectual property rights, and they are distinguished by the nature of the product on which they manifest, or the end product that comes out of human creative effort. When we peg the definition of intellectual property right to human creative labor, that itself creates some problems, because we have today something called geographical indications where no human creative effort is technically involved. But nevertheless, when we put the emphasis on human creative labor, we are referring to the origin of intellectual property, because intellectual property originated through copyrights and patents. That was the two initial rights that emerged. So there are different types, and each type refers to a different category of products. Patents are used for protecting inventions, and when we talk about inventions, we are referring to technological inventions. Copyrights. Copyrights are used to protect literary and creative works, literary artistic works, soundtracks, videos, cinematography, computer programs, and a whole lot of things. Designs. Designs are used to protect what can be distinguished by the eye. For instance, the law of designs is different from the law of patents, because designs are not used to protect something that is functional. Designs are used to protect something that appeals to the eye, something that is visually appealing to the eye but does not have a function behind it. Trademarks. Trademarks are used to protect words, symbols that can be attributed to trade. Geographical indications can be used to indicate the origin of certain goods. Trade secrets can be used to protect information relating to trade which the owner of the information wants to keep as a secret. And there are other intellectual property rights which we will discuss in some detail as we go by.